anyone that doesn't know me, I'm Clara Rose. I run Clara Rose Consultancy, and I'm often asked the question about whether people can transfer skills from one area of law to another. And we talk to people about questions outside of can I have a new job all the time. So we do try and sort of have as much information as we can for people to really help people with what they're trying to achieve. And I know Gill from back in legal training days when I was working in CPD training, and she offered to sort of come online and do a chat about, you know, whether private client is the sort of area that you might like to get into, whether it's the sort of area that you could change over into and have a alternative career, you know, it's still in the law, still using lots of your skills, but in a different area of law. So yeah, Gill, over to you. I'll let you introduce yourself, and we're going to have a bit of a sort of presentation from Gill, and then at the end we can ask questions. You can either sort of put your hand up and ask the questions yourself, or you can pop them in the chat box, and then I will ask them to Gill. But yeah, Gill, over to you.
Thanks so much, Clara. Well, thanks for the opportunity. As someone who's exclusively worked in private client all my career, so nearly 40 years now, I have actually got, I hope, quite a lot to tell you, which I've plucked out of the air, but also from experience, actually, because I have been training for 25 years and I have done a lot of conversion courses for people who are looking to move into this area. And it is quite an interesting area, dare I say. I absolutely adore it. So I can understand why others might be vaguely interested, and I hope I whet your appetite in have you got what it takes to be a private client lawyer? Because I want you to be able to understand some of the issues, because as a lawyer or a prospective lawyer, you've probably got some of the skills already, but we just need to tweak it. We just need to understand what makes this area tick. And I'm hoping that therefore what I'm going to do is going to give you that chance to think about whether you have got those things. So I'm going to talk about some of the issues that are involved in private client work. And I hope that you'll end up with something that will enable you to make a decision as to whether you think it's worth exploring further, because you probably will have to pursue some further study in order to be of any use. So I've posed the questions on the slide. I've posed these questions. What does a wills, probate, trust and tax and elderly vulnerable client work look like? What do the law you need to know include? How are the different subjects connected to each other? And I think that's probably something you'll find interesting. And then I look at a few comments really about whether you are operating in a level playing field here with other people offering these services, and therefore what steps should you take? So some people would include in the question or definition of private client work, conveyancing and family law. I'm not doing that. I'm looking at it from the point of view of wills, probate, trust and tax. And that's the area where also vulnerable clients sometimes sit in many firms. And the first thing I would say is, well, what skills do you need? This is basically attention to detail. Now, that's not to say that lawyers don't generally have this skill. It's simply to say that it's particularly relevant here. The sort of things I'm getting at is that you're going to be creating documents that will potentially have to last for many years, like wills and trusts. So accuracy is very important. Also, you're going to be dealing quite a lot with figure work. So it could be in relation to tax, it could be in relation to estate administration. So you're going to have to deal or be happy to deal with accounts and be able to spot where things might go wrong. You're also going to be working with not just the client, but third parties. So asking them questions, drilling down into information that you need in order to get the job done. Particularly in this, I'm thinking of estate administration. When you're dealing with people to take instructions, again, like pretty much every area of law, you're going to need to make some contemporaneous notes. But what we've seen in recent years, and I'm talking here about the last 15 years maybe, is an increasing amount of contentious probate work, and therefore where your file will be examined potentially by a litigator, where you will be possibly having to give evidence in court and simply saying, well, my usual practice is I did this, so I presume I did that in this case, just won't wash. You need to be able to say, well, can I refer to my attendance note of the 6th of January 1995? In that I recorded these things. And that's the sort of thing that helps you to do. Obviously, to minimise risk, people will put in place in a firm plenty of procedures that need to be followed. That's again true of any area of law, but it's particularly important that you follow some of them, particularly with will writing, for example. There are some good practice rules that are generic, and a firm therefore may require you to do certain things. And the reason for that is because you're trying to comply with something called the golden rule, for example. Checking again that everything is correct and things are going to the right people. If you're making a distribution from an estate or from a trust fund, or you're handling the money of someone who's vulnerable and are distributing it perhaps to pay a bill rather than to an individual who might be looking for a gift, these are the things that have got to be checked and correct. Like many areas of law, you're going to have deadlines, and therefore managing those deadlines and not missing them, and having a good diary system in order to be able to make sure you don't miss them is very important. Also, there is a wide range of capabilities working within a private client team. So the ability to lead a team can be very helpful, to be able to delegate work to the right level in order to make it economical and therefore profitable is really quite useful. So these are some of the attention to detail aspects just specifically tweaked to fit to private client work. The second thing, which is absolutely big on the private client lawyer's list of skills, is the ability to empathise with clients. When a person is what you might call simply a customer, then they become a client. You know, they will come to you as a client for the future because you have treated them well as a potential client when they were simply a consumer of your service at the start. And it's also terribly helpful when you're dealing with the older client, which not all clients that we deal with in private client work are old, quite the contrary, but there is a predominance of older people who are perhaps beneficiaries, who are perhaps the people who need protection, who are the people that we may take instructions from initially. So they are people who we need to be able to gain respect from so that they will listen to us and be willing to work with us. Obviously, collaboration is more than just with the client, it's internally in the firm. For example, if you're trying to build a client base, then you need to work with your conveyancing colleagues, your family lawyers. They're the people who are going to refer potential clients to you for wills. You're going to want to be able to deal externally with third-party referrers like accountants. They often refer business clients. And so these are the sort of things that really make a big difference. And obviously, from my perspective, when I talk about having empathy, I'm talking about having this positive attitude that you are really engaging with a person, really listening to them, asking them questions that are relevant to what they've just said, so they can tell you're picking up on what they've said to you, that you're truly listening to what they've said. And this enables you to demonstrate how important it is that the service you can offer them is right for them, not something that you're just trying to sell, but is actually appropriate given what they've told you and what you've explained as a result of their questions. And so your ability to provide this help and support becomes very clear. And when you're dealing with bereaved people, this is something which obviously everybody experiences differently. But in my experience, there is what I call a 3-month wobble, where particularly a widow would be at a loss when the normal support from their family and friends sort of drifts away by then, and you're still the only person that's really in contact with them. And they will lash out at you, they will be unstable perhaps at that time, and how you handle them will make a big difference to A, how they cope, and B, how they will regard you and your services for the future. And that's the sort of thing where, you know, helping them at that point will make you a client for life, and they will be your referring engine for everybody in the location. And the other thing you need is to be, as you probably would expect, very organised and methodical, because, again, like some other areas of law, you're probably dealing with loads and loads of data. So much of the law requires us to have a systematic approach to the handling of that data. These days we use computers, and we may store a lot of this data electronically and maybe can interrogate it electronically, which can be very useful. But it's certainly something where even if you don't have the relevant software packages. You do have to be able to find that piece of paper in trust administration that could go on for 80 years, 100 years, 125 years. When you're running that trust, you might be just a mere cog in its lifetime, but you've got to be able to find that day when there was a holdover relief claim made for capital gains tax, so that when you sell that asset, you can work out the capital gains. It's no good saying, well, I don't know, I haven't got a clue, where do I start? You've got to be able to find it. So systems and organized approach to life is really helpful. There's a high degree of technical work here, and you would have to study to learn it. That's goes without saying. So in each of the areas of wills, probate, trusts and tax, there is a whole raft of legislation and case law. But at the same time, there's a lot of practical stuff going on. So you could perhaps afford to study that technical stuff in the background whilst actually doing a fair to decent job of probate, for example, where you are, I say simply, but you're writing letters of a standard nature, collecting the data and presenting it correctly in accounts and keeping the client informed. I think anyone who's a lawyer should be able to do that. Obviously, if you can use computer systems and are willing and able to spread your wings beyond Excel spreadsheets to more bespoke software, then this is a great area for you, because there are some good support software out there. I have to say, you might be the reason why a firm suddenly adopts it, because up to now there hasn't been someone who is so computer literate who's willing to experiment with it. So that could be a good sales pitch for you. You certainly do need to be able to look up the law, and you do need to be able to instruct counsel from time to time. But even when you're just keeping yourself informed of developments in the law, there's a lot of case law, for example, and that can be very important. So it's certainly good if you've got that research skill, that sort of I like looking in books elbow. It really can be beneficial to your development. And if you are excellent at designing systems such as record keeping or other kinds of system to streamline the processes and procedures that a firm has, that could be, again, a really ace card up your sleeve. So what kind of law do you need to know? I've talked about acts of parliament and I've talked about cases. Well, taking each area as a quick example, the Wills Act, would you believe, is still good law, and it's 1837. Yeah, that isn't a typo. And it still governs most of the areas in relation to making a will. So that certainly is under review at the moment, but it's taking quite a long time. And of course, we had COVID, so the Law Commission is a bit behind. But nevertheless, that is the law, and you could easily read it on .gov legislation. Obviously, there's precedents out there. You've got to be used to looking up precedents for drafting wills and putting them together in a sensible fashion. As I say, there are software programs as well now which are becoming popular, not having been so for a long time. And if anyone's interested in that, if you go onto my website, details at the end of the presentation, if you go onto my website, there are, under free resources, a software analysis of what's available for will drafting, if that's something you're interested in. So precedents are developed. They're usually followed from textbooks and things which maybe have been asked to be drafted by counsel, and sometimes we do have to do some of our own drafting, and they will be divided between those which have precedents which are based on decided cases from the past, or they might be written in plain English, and it's a question of style as to which you like to use. Obviously, as I said, it's an area of lots of case law, helping us understand the way the interpretation of things should be done. So, as I said, the Act is 1837, but Section 9, which talks about how a will is formally signed, that is about validity. There's been quite a few cases right up to present time on that particular area. Will preparation also tends to work with people who may have some frailties, and so the question for us is assessing whether a person actually has capacity mentally to make a will, so known as testamentary capacity, and that is an area of great and growing challenge as the population ages. So again, being able to talk and assess someone's mental capacity to make a will is pretty important. Probate, and therefore estate administration in general, is when somebody has made a will, then you're getting a probate of that will. If they haven't, they die intestate, and therefore you're administering the estate as an administrator. So again, we have an Act of Parliament, the Administration of Estates Act of 1925, which gives us a framework for administering both types of estates. And also we have now an online system, which is very new, with the HM Courts and Tribunals Service, which took over the probate registries. There used to be 30 around the country, compiled of full registries and part-time registries. That's all gone now, and we have an online system run out of Birmingham. We have one office in Newcastle that deals with complicated paper applications, and we have a system in Harrow which scans in original documents. But otherwise, everything is done through the online system, which has been very painful in its introduction and has caused huge delays in times past, particularly during COVID. And the current time, it's taking approximately 8 weeks to get a grant of probate. When I was full-time in practice, if I didn't get my grant within a week of making the application to my local registry, I would be wanting to know why. So things have not necessarily gone forward. And our non-contentious probate rules, they date from 1987, but they've had a lot of amendments in recent years to accommodate the online system. So the probate registry issues the grant. There's different sorts of grants of representation, but it's that which enables us to then collect in the assets and sell them if we need to. So the registry acts as the adjudicator of checking the validity of the will from the face of it, rather than from any accusation that the person lacked capacity, for example, which obviously it can't deal with because it's a non-contentious office. And if someone wants to challenge the validity of a will or challenge whether or not it's the last will and so forth, that has to be done separately. So administering estates that aren't challenged usually involves some knowledge of tax work. Even if it's not a taxable estate for inheritance tax, there will be tying up the loose ends of the deceased's own personal tax affairs. And depending on how complex their estate is, there could be quite a lot of work in that area. You also will have to prepare accounts. As a professional, you'll be expected to prepare accounts, and this is why a bespoke software can be extremely helpful. Many firms don't use that, they just use an Excel spreadsheet. It doesn't actually matter. It's all about time and effectiveness. But I have to say that you've got to be able to demonstrate that you've dealt with all the assets of the estate correctly, and a set of accounts helps you do that. Trusts are really a fascinating subject. I've really loved working in the area of trusts all my life, and I was lucky enough when I first qualified to work in an old established small firm who had a niche in trust work. And I'm sure had I gone to a London firm, I would never have got my hands on some of the fascinating work I did when I first qualified. And it was really as a result of what I learnt at that stage and further research that I ended up writing the Trust Practitioner's Handbook for the Law Society. So trusts are an English invention. They go way back to the Crusades, when the Crusaders had to leave their land to fight for the king in the foreign parts. And to leave land not being maintained was a recipe for ruin. And so the only way that they could transfer managing the land was to transfer the legal title. That's all that was available to them at the time. And so when they did this, it was on the gentleman's handshake that when they came back, it would be transferred back to them. But guess what? When they came back, those that did, quite often they were not given the land back. And so they petitioned the king, who asked the Chancellor of the Exchequer to set up a court to look into this. And so over the years, we got the development of the courts of equity, which were entitled to look at the fairness of situations, not just the black letter of the law. And from that, we ended up with what was first of all a use, that's USE, which was the enabling mechanism to let the Crusader use the land. And that was in existence right up until Henry VIII's time. And Henry VIII wanted to be able to tax everything because he was desperate for money trying to fund his wars. And so basically he decided he had to abolish uses. and he eventually managed, after several attempts, to do so by the Statute of Uses of 1536. But the concession he had to give was that if it was an active use, in other words, if the legal owner was actively managing the land for the use of the beneficial owner, then it had to be allowed to continue and wasn't taxable. So right at its beginning, a trust, because that's what a use became, basically was helping us with mitigation of tax. It's a way of managing the assets for someone, sometimes those who are not yet born, sometimes people who are vulnerable, but in the end, just protecting the assets. And it involves, therefore, two aspects: drafting the trusts, of course, which we use precedents again for. Not quite so many of these available as there are for wills, although wills themselves have trusts contained within them. And sometimes we go to council, depending on what's at stake. But nevertheless, they are the place, the precedent books and the textbooks help us to understand the drafting again and get the right trust in place. So trust drafting is one aspect of it. The other aspect is the administration of the live trust. And so these can arise, as I say, from trusts under wills. So when the probate's finished, the trust would continue, or it could be a trust created during someone's lifetime. So again, you're managing the assets, you're preparing accounts, you're doing the tax returns, and crucially, you're keeping those records over the whole life of the trust. I have to say, in smaller high street practices, trust administration is probably not enjoyed, and it's done alongside wills and probate work usually. But the bigger the firm, things like banks and large firms, they will have a whole department that only does trust administration. So there's a very variable experience out there. Again, we've got a couple of acts that are relevant: the Trustee Act of 1925, much of which is still relevant, and then the Trustee Act of 2000, which came along following Big Bang in the city to enable us to manage the money more easily. So that's very important. There's also been a number of finance acts, as they often alter the tax treatment of things, and the critical one for the tax treatment of trusts was the Finance Act of 2006. Yes, there are the boilerplate books on the law relating to trusts and trustees of Lewin and Underhill and Hayton, but my little book, the Trust Practitioner's Handbook, helps you with actually administering them. So it's let's turn to tax, because it's almost synonymous with trusts actually, and it's not just accountants that deal with tax. If you are interested in tax, there's separate qualifications as well as your solicitor's qualification, and they can be very useful to you. Tax planning is something we do for wealthy clients, often against their instructions for making a will. We might take on board the creation of a trust as part of the tax planning exercise, and sometimes tax work is therefore referred to us, and the legal work might be done by us, and the tax work in fact might be retained by the accountant, for example. Tax work, if we do it, not all firms do, can involve the nitty-gritty of completing tax returns for clients. It can also mean that you are therefore managing the payments and the repayments of tax. You're checking statements of account, and again, maintaining records. Most of this now done digitally. But since tax affects most probate cases, then it's really quite difficult to be able to do probate without understanding inheritance tax. And also you'd have to finish off the person's tax returns, as I said, for income tax and capital gains. And the same with trust work. You can't really understand trust properly unless you understand how each different type of trust is taxed. And if we take on work as an attorney or as a deputy for an elderly or vulnerable person, we're managing their finances, and that often means looking into their tax affairs. Tax is only one aspect, of course. Elderly clients present any range of issues. It's whether or not your firm is equipped to deal with elderly people. And so sometimes it might be helping the family of the elderly person, help them with their care planning and what's needed for that. It could be that the power of attorney was put in place before they lost their capacity to make decisions for themselves. And so you are enabled, either directly as the attorney or as agent for the attorney, to actually run their affairs for them. And of course, it does mean that we want to be able to step in in where appropriate if we can to help those who are vulnerable to financial abuse, which, believe me, does exist. So we might be preparing lasting powers of attorney, we might be applying for orders as a court of protection, asking for a deputyship order if there's no power of attorney, and we will be dealing with the Office of the Public Guardian and the Court of Protection in this area. In addition to managing finances, we could be helping families, enable them to talk about the welfare of that person. So in other words, they might also need a health and welfare power of attorney. Deputyships for that are rare. It's usually left to the best decisions of the people who are closest to the person to make those decisions. So vulnerable clients don't have to be elderly. That's the point. They can be all ages, and many cases will involve people who have lacked capacity from birth, perhaps because of an illness or disease or because of an injury. And so we need to be fully aware that the Mental Capacity Act of 2005 isn't just directed at elderly people. It's also there to protect anyone who may have difficulty in making decisions for themselves. This is backed up with the Court of Protection rules, and also in relation to the way that care is provided by local authorities by the Care Act of 2014. The Care Act is merely a framework, and it has got oodles of regulations and over 500 pages of guidance as to how we make decisions about supporting someone who needs care. So some firms call this later life teams because they're focused on the elderly vulnerable. Some call it community care lawyers. There's different phrases that are used for a team of people that might support the managing of the finances and the handling of the care needs of people in this position. It can be very fraught because you're often up against government departments or the NHS in trying to agree the care package. It can mean that you've got even to go to court over it, and certainly fighting refusals of particularly the NHS continuing care package can be quite a specialist area because there's lots of multidisciplinary partners involved here with GPs, social workers, and basically the lawyers as well. So there could be quite a lot of specialism around that. So it's a very practical area of practice in that you're perhaps organising, running a home for a person to carry on living at home. So you're doing it, let's say, under a power of attorney. So you're contracting to employ carers, you are managing the money, you are paying for tradesmen coming and going, you're ensuring the welfare day to day of that person. Equally, if you're dealing with the family of an injured person, you could be managing a huge trust fund, which has to be utilised for alteration and adaptation to their home in order to care for their loved one, and 24/7 care packages and that kind of thing. So normally that will be run by a partner, let's say, who might be the deputy or attorney, whereas underneath that person will be a raft of more administrative people who can do the day-to-day work more cheaply. So it's a wide variety of work there, mainly of an administrative kind, but dealing with people sensitively and carefully. So I think the next bit is what will perhaps help you to understand how these different areas of private client work connect up and how you might make some kind of impact if you went to a firm. I think for many, especially if you were trying to do some business development, it starts with a will. Quite often people know that they want to make a will, or they have been recommended to make a will. And so therefore it tends to come as work when you're in a firm from existing clients. So a bit of cross-selling internally. And as I said earlier, this often comes from people when they're moving house. So your conveyancing colleagues could suggest that they need to update their will now they're moving somewhere else, or buying for the first time, now owning a significant asset, even if it's in mortgage to a mortgagee. And another area where it's often the case where people need to think about making a new will is pending a divorce and whether or not they need to appoint, for example, a testamentary guardian, and the nature of the beneficiaries and how they need to be protected. So that can suck in from your existing clients' new work. But you can obviously go out and get new clients, but this is a much harder prospect. It's helpful if you've got some contacts in the community. So if you are a mum or a dad and you've got friends at the school gate, this can be a great source of work because you can explain how important a will is to a young family to ensure that the testamentary guardian is appointed, that a suitable trust is put in place if the worst happens. So it could be your own referrals, but it could be referrals from third parties like accountants and financial advisors. So those are the easiest way to get clients, be they work from existing clients or be they new clients. Obviously, you can go out and do marketing, and some of that can generate some new work. It might even give you a big scheme from a local employer or an agent like a trade union. These would be big clients for a firm. But nevertheless, these things do exist and people do need that help. So a will is often the way in. But please be aware that don't always have wills as loss leaders, as historically they have been. It costs a lot to produce a valid will where you've taken into account the risks to the firm. And the risks got very large from 1995 as a result of a House of Lords decision, and people don't take care enough about that. So who do you owe your duty of care to? Not just the person you're drafting the will for, but the people who may lose out as a result of your negligence. So that could be beneficiaries or potential beneficiaries. So the risk net got wider, and one should factor that into the costs you charge. So again, looking at the connections, if you start with the sorts of people who make wills, there could of course be people like our elderly clients that didn't necessarily have tax issues, but were more interested in having their end of life things managed effectively, and so wanted to have a power of attorney. So EPA was the old enduring power of attorney, replaced now by lasting powers of attorney, LPAs. There may be a reason to help them with a care package. You've gone to see a client about making a will and seen that they're not managing and could be entitled to attendance allowance to pay for some care, that kind of thing. It could be that they want you to do ancillary documents, not just the power of attorney, or they might want you to do an advance directive, which is saying what they don't want by way of medical treatment in the future, for example. It could be that the client is taxable and therefore they're looking at how to cover the impact of the value of their matrimonial home is in their estate, how to deal with their high net worth income and capital. And so therefore you might be looking at ancillary matters to do with that more in a moment. It could be that the choice of beneficiaries they're wanting to benefit is actually complex. It could be that they've had more than one partner and have got a variety of children from different relationships. It could be that one of the beneficiaries is disabled, so there might be a need for particular advice in relation to that. You could have the assets themselves that are complex, and that's frequently the case where someone has a business asset. It could be a farm, it could be a partnership or a company. It could also be that the assets aren't in England and Wales but are actually in a different jurisdiction, and that makes it more complicated. And so our clients who are taxable might want some lifetime planning to help them, but it could also be from their will as well, that either way, that process of looking at the taxability of their estate leads us to suggesting trust might be a useful output. So this is how these things connect together. So as I've said, from an elderly client's point of view, they might come in for a will, but you also are going to be recommending a power of attorney, and you're going to be looking at their state of health in the near future, and that might require registration and looking at the way the care for them is paid for. So that's how that end works. And equally, they may come to you for a power of attorney and you realise they still have capacity and they could make a will and they perhaps need to do so. Obviously, when it's probate, we've lost the clients, because the chances are the probates we often get are those where we hold the will. It's not always the case, but often the case. And so we've now lost the clients, a valued client. So how we handle that process of dealing with the probate of the estate, and how we were when we empathised with the beneficiaries, how we dealt with PRs and any potential conflicts, is going to mean that we might pick up some new clients to replace our deceased client, because we've handled it so well that the other people are saying, oh, well, we're going to recommend you to other people. And will you do our work as well? That's often how it happens. Again, within the probate process, you get specialist areas like overseas issues, where you might have to get a grant in another jurisdiction, where you might have to administer assets in another jurisdiction, where you might have a conflict of jurisdictions imposing their will on a particular estate. And with the probate of a will, where there is a trust contained in the will, once you've got to the point where you can appropriate the relevant assets to the trust, then of course you've got the ongoing administration of the trust should you so wish, and that is how that fits in as well predominantly. I would say that probably 70% at least of trusts that most solicitors manage are ones that have arisen out of wills, but you know, it varies from time to time in the sort of firm you're working in. So, is it a level playing field that we're operating in? I thought it was worth putting this in, because I don't want you to go away with the impression that it's highly technical and specialist, which it is, but we're the only people doing it. Unfortunately, there's parts of the work that are not reserved legal services, and therefore it's open to competition. So the classic, which you probably already know, is that despite the significance of making a will, it is an unregulated service. So it's only regulated if it's the solicitor doing it. And so we're regulated, and anyone we employ is regulated, and barristers don't tend to do much of that, but obviously they could. But obviously we're all regulated. And there are members organisations like STEP, like the Institute of Professional Will Writers, like the Society of Will Writers. These are not the same. They are membership only organisations which could remove membership from someone who doesn't fulfil their list of requirements. But it's not hard regulation that you and I know. So literally you can go to Tesco's and see someone outside selling will writing for $19.99, and there's nothing you can do about it. They're entitled to do that. Probate, on the other hand, there is an element of probate which is regulated, and that is the extraction of the grant. But everything else isn't. So you can have non-authorised probate practitioners doing the work using a power of attorney from the executor, because an executor can always administer the estate themselves. And so they can choose to give a power of attorney to an independent person, could be an IFA, could be their friend from the pub, and they can then go and get the grant based on that personal application. Anybody else has to be an authorised probate practitioner. But of course, the banks and other institutions simply employ an authorised probate practitioner to do that little bit of the work. So I have to say that it's basically bankers and accountants who can be authorised probate practitioners, and also legal executives if they're independently operating. But essentially, that's it, apart from solicitors. So effectively, that's also a very profitable area of work that could be undertaken by trust corporations, who are simply set up to do the work and employ lots of people doing it, but they're not actually regulated. Trusts themselves, they should only be drafted by lawyers, so that would be solicitors and barristers. But I have to say, I've never known that particular piece of legislation enforced. It came originally from the Solicitors Act before the Legal Services Act of 2007. What insurance companies do, because they tend to offer insurance products written into trust, so they employ lawyers to design standard documents which IFAs then complete. So that is the way they deal with it. But anyway, whoever does the trust drafting should be compliant. Trust administration, well, there's no particular regulations there. Obviously, again, as lawyers, we have to comply by our regulations over holding client money and that kind of thing. There's no definition, would you believe, of tax advice in the tax code, but there is in the anti-money laundering legislation, and they're not terribly clear, I have to say. So tax advice or tax advisor is something which HMRC would love to get some standard rules around, some actual conditions attached to it, but at the moment you don't have to be qualified, you don't have to be in a profession. The only thing you have to do is to be regulated for your anti-money laundering side of things, and so you can be regulated by HMRC for that purpose. Obviously, as lawyers, we do have to comply with professional conduct in relation to taxation, which is a relatively new thing, which actually we weren't involved in. It was the tax bodies, so it was the Association of Tax Technicians, the Chartered Institute of Taxation, the Institute of Chartered Accountants of England and Wales, and basically STEP came in on that as well. And it was only after they had agreed with the revenue, the standard that would be set for those working in this area, that the SRA said yes, solicitors should comply as well. But there aren't any other particular standards. So just to bring this little bit to a conclusion, let's think about what you might do as your next steps. Let's, as I say, regulated practice I've mentioned. So let's think about the next steps. I think I would suggest that you reflect on your personal skill set and think about some of the things I've mentioned as to whether that's something that you would feel comfortable doing. If you're lucky enough to already work in a law firm and there is somebody doing this work, then go and talk to them, chat with them, see if it's something that you have understood and feel that it's something you could work on. And as I say, play to your strengths as much as you can. That's always better than trying to address weaknesses, to be honest. And so see if there's something that you can pull out of this which fits with what you like. For example, if you're a litigator by profession and you like that cut and thrust of court work, then it may well be best to specialise in contentious probate, of which, by the way, there's an awful lot, and learn enough probate to be able to give proper advice in that area. Obviously plan, because if you don't plan to get to your goal of becoming a private client lawyer, you never will. Think about some of the things I've said about what's needed and why you need to get there. And obviously then have a plan for when you need to do it by and how you might approach it. It could be that you look to getting a mentor. It could be that you build on a plan for learning and development, because for you, the way you learn might be listening. It could be doing. So try and find a way to build those in. As I say, one way I've suggested in the past to particularly ladies, forgive me gentlemen, who come back from maternity leave, realizing they don't want to work in the city anymore, wanting some kind of part-time job to exercise their grey cells. And I said, well, probate's excellent for you because you could do that part-time. And there's really a way in here to say, well, why don't I help you, law firm, to get your will bank dusted off and brought up to date, because there's always loads of wills that are out of date in law firms' will banks because people have moved away, they've done new wills, and by writing to those clients you can say, do you need to update your will? This is something where a busy private client lawyer hasn't got time to do it on a mass basis, but going through that process and perhaps encouraging the use of Certainty National Will Register to register those wills when you've brought them up to date will encourage the work into your firm for probate. So this could be a really good way of doing it, and it's offering a service that could be very beneficial to a firm while you build up knowledge and skill. But basically think about how you've learnt in the past, and obviously if you do work in a firm that's looking to enhance the private client team and you could put yourself forward, then get your line manager to think about it. And obviously you want to be able to get their support. But if you can't do that, if you're outside of those parameters, then you could always look for an external coach or mentor. And of course, as you know, the best way to prove something to somebody is to have evidence. So record all that you do on the way to building up this knowledge bank. So basically, now you've decided this is what you want to do and you've got a plan, think about how you're going to do it. You will forgive me for suggesting that you might like to look at my website. After all, this is how I make my living these days. So Law Skills is my company, and we have a web shop. And on that web shop, I've done specially for you a set of introductory courses when I've gone into much more detail about each of the topics: wills, probate, trust and tax. So you can really see over the course of maybe a full hour what each of those involves. It's £40 for each of those, but if you want to look at all of them, only £80. So it's worthwhile having a look at that. As far as looking at books, a really helpful, handy book is Parker's Will Precedents. It's not too expensive. It's all in one volume and it's got some precedents in there, but also some commentary. That would give you a nice flavour about wills. The Probate Practitioner's Handbook, produced by the Law Society and edited by Professor Leslie King, highly recommended to pick out some key details about probate. My own book on the Trust Practitioner's Handbook, produced by the Law Society as well. There's an IHT planning handbook, also by the Law Society, and an elderly client practice manual, President manual, that is by Caroline Balenska, the leading light in that area of practice. It's by Jordans and it's in the 5th edition. So that will give you a basis for each of those key areas to drill down into. And then there will be detailed courses out there. Myself, I offer a detailed self-study course, which is 10 modules that you can also download off my website. But there's also the Society of Trust and Estate Practitioners, who produce certificated courses as well. So I hope I've given you enough encouragement. As I say, go and have a look at the web shop, and also do look at the general www.lawskills.co.uk website for free resources as well. But the web shop is where you'll be able to buy things. There are other webinars on there, not just the ones directed at introductory matters. So your success will be you've got yourself involved in a team with the right skills, and certainly your skills could help the firm become more competitive. You could help expand the range of services, saying to a firm, well, you don't do this. This is an area of private practice I would like to help you with, such as contentious probate. You've found an area that matches your skills and your values and beliefs, and it's great. You've really got yourself into something you enjoy. And actually, by moving that little bit out of your comfort zone, you've now reached that nirvana of fulfillment. So over back to you, Clara, in case there's any questions. I hope that's helpful.
Oh, fantastic. Yeah, that was also useful. Some of the it's been a long time since I did any wills and probate training back in my degree. And just the thought of the Wills Act being in 1837 slightly blows your mind, doesn't it? But
it really does, yeah.
And the bits about trusts and the Crusades as well, you know, it's actually, it makes more sense when you put it in that context than perhaps it does now. So yeah, it's just really interesting. But yeah, we had one specific question come through. Some of it was answered by your resources on training, but there's some more to it. So I'll just sort of read it out. So this is from a qualified solicitor.
Yes.
Who thanks us for running the webinar. They say it's been more than a decade since they did the LPC, where they studied private practice, and since then they've worked almost solely in personal injury and clinical negligence.
Right.
What would I need to do to be able to run private client cases now? I appreciate simply having a textbook, etc., is insufficient, as so much knowledge is gained through practical experience. Ideally, I'd like to set up on my own and offer private client services if possible, but I certainly wouldn't just go into that without proper training.
No.
Sort of any suggestions, much appreciated.
Well, what I always say to people is, strange as it may seem, probate is the safer area to try and get into. Now, that's sometimes difficult because, as I said in the talk, quite a lot of probate work comes from holding a will for somebody. But it's less risky than will drafting. So many people think, well, anyone can draft a will. There's a precedent book. I'll just lift that out and that'll be done. But unfortunately, wills is the biggest area after conveyancing of claims for professional negligence.
I didn't know that.
And if one talks to the Solicitors Indemnity Fund, which is still hanging in there by the toenails, isn't it? But it basically would tell you that the negligence tail on a will that you draft today is 20 years on average. So that is a scary number, because most insurance runoff is 6 years and the SIF is 15 years. So you're looking at claims potentially after your PI covers excluded. And that's simply because people don't always change their wills as frequently as they should. And if there's an error in it, it might not come to light until they've died. And therefore, that's when a problem arises. Let's take a very simple, quick example of that. There is a Supreme Court decision on 2014 involving a modest estate of a husband and wife who left everything to each other on the first death and then left everything to X on the second death. X was not their son. They did have 2 children, but they were estranged from them, which was why they were encouraged to make those wills. And X lived with them, was a lodger, and he looked after them, etc., etc., etc. Now, the fact of the matter is, why was that ever in court? Because guess what happened? The wills as they stood were fine, but mum signed dad's will and dad signed mum's will. Now, that's easily done. Anyone could do that. They were supervised by a solicitor, but of course, in chatting to them, they obviously gave them the wrong documents. They didn't read them. They signed them. On mum's death, it didn't matter because everything went anyway by survivorship to dad. It was only when dad died when it was mission critical, and it couldn't be said to be an error in the drafting, one would have thought. So how do you correct this? And it went to the Supreme Court because in the end there was said to be clerical error here, which is quite interesting. And it was all about trying to ensure that the wishes of those people were fulfilled. And clearly they wanted to make those wills. It's just that they signed the wrong one. So they agreed to rectify them and allow for the whole of the one will to be rectified to include the right pronouns and so forth. Now, that is a classic example of where wills can produce risk and that you never know until you open that blooming cabinet and pull out the document. And that's why I say it's such an easy thing to get wrong. And I would say practice makes perfect there. Having someone to work with makes a huge difference. And so it's quite difficult. I was talking to a solicitor not so long ago where she came from a family law background. She's trying to do the step exam. She wants to move into the private client side. She'd been doing wills and she came to me because someone had died and the will she drafted had produced all kinds of problems. And yet, you know, she thought she'd done a good will and then she realized she didn't. And so that's the trouble. When you come to look at it later, that's when the horrors start to come. So I would say that does need practical experience, and it either means you've got to pay for that if you're doing it on your own. So you're having to go, let's say, to a consultant or, you know, even dare I say junior counsel until you've got used to it, and that's expensive. Or if you're lucky enough to work in a firm where there's somebody doing that work, then you can work with them to build up that knowledge. So it's pretty hard to do unilaterally. Whereas probate, frankly, with a good software program and common sense, you can do one hell of a lot.
Okay.
And it's profitable. And so wills aren't necessarily. So I would say if you were seeking to do this yourself, particularly if you've got PI and critical negligence side of things under your belt, then if you've been used to administering those trusts, it would be an easy transition to do probate.
Yeah. No, that's interesting, isn't it? That's it, because like you say, the wills, you naturally think wills, one document, straightforward, you know, probate,
everybody does.
Could be a whole can of worms. Do you know what I mean? But yeah,
everybody thinks any fool can write a will because it's not regulated. Well, there are plenty of fools out there who wish they hadn't.
Yeah, I'm sure. No, absolutely. No, and I think as well, say it's what I like about what you were talking about is sort of you give a real flavour of all the parts, because I think that's the thing as well. It's sort of it's understanding all the parts and how they fit together.
Yeah.
One question that sort of came to my mind was the day to day, because I know lots of people mention this in sort of private client work, how much would you say you're sort of in the office and out of the office and visiting clients and this sort of thing? So I know that's such a key part of it, isn't it? Is that actual sort of face to
Well,
face with clients? But
yes, face-to-face clients is quite a big element of it. I would say it varies a lot, especially now that we're all using Zoom. With a lot of clients, and again, I'm focusing here on the older ones or the ones who aren't so mobile, they very much appreciate you going to see them at home. How to make that cost effective can be a challenge depending on what you see your geographic area is. But nevertheless, it can be a sensible thing to offer and do. But you don't have to do it that way. Now you've got Zoom. It does make sense, though, if you're dealing with older people to see them, because you often have to do a mental capacity assessment and you really can't beat doing that face to face.
okay, yeah.
It can be quite time consuming, and usually that's where those extra skills come into it, because you might be looking at saying, well, we can't do a will, but we really do need to help you here, and we need to sort of think about other things like getting a deputyship order in place and things like that. So can I talk to your family and can we make it a bit more of a general support thing? But as far as taking will instructions is concerned, there's a lot of clients are still happy to come into the office. A meeting, probably if you're going to do it well, is probably not going to be under much less than an hour. So it's a big chunk of your chargeable time. And don't forget, you're often selling this at a fixed fee. So one of the horrors really of private clients is with wills, unless you're charging by the hour, you're writing a lot of chargeable time off. And that's why I say the probate work is more cost effective, because you're usually charging a blended rate. Even if it's a fixed fee, it's usually been a bit more scientifically designed around the value of the estate, and so you're probably going to get a decent return on your investment of time. Wills, that's rarely the case, because unless you are prepared to put your stall there and say, well, look, I'm dealing with a businessman here. The estate advice I'm going to give you is just as valuable as the will I'm going to draft, and that costs money. And so it's not going to be £100 for drafting this will, by the way. It's going to be £1,000. And we shouldn't say, I'm sorry, it's going to be £1,000, because why debase your skills in that way? You just got to be confident about it. And so, yeah, so I think there is a lot of client contact for sure, and there's a lot of beneficiary contact, which isn't necessarily the same, and there's a lot of family contact, because often, depending whether you're dealing with elderly people or vulnerable people, you might be dealing with their family as well.
No, absolutely. No, that's interesting. And you said about the charging as well, because I know from my experience with probate, how banks do it, and they do it on like a percentage, don't they, of the estate, which is like that sort of blew.
Yeah,
Made me think, I can't imagine a solicitor doing that, you know.
But some do these days.
They ought to if banks are doing it, don't they?
Well, I think the thing with banks is they don't only charge you a percentage, they charge you per letter. So you often have a fee that grows very quickly, because it might be X% plus £8 a letter or something like that. I think the models are very wide now in relation to probate, because people obviously do like fixed fees, and I've got no problem with a fixed fee at all. My point is only fix it at a competitive rate that is fair to you as well as the client. And that usually means when you're fixing a fee, you should fix it a little bit higher, because the client's getting the benefit of knowing that come what may, that's what you're going to charge. Whereas if you say I estimate it's going to be X and it proves to be more, then they get disappointed, and so do you if it takes you way off beam. But nevertheless, if you fix it at this level, and the amount of time you didn't really think about carefully enough, and you're doing this amount, you're going to be fed up, and I would guarantee you probably aren't going to do your best work, because you're going to be trying to fit it in around everything else. Please don't try and do that classic thing of juggling court work with probate. I mean, the things just don't mix, because guess what left behind? The probate file gets left, because no one's chasing you, they're dead. And apart from your beneficiary saying, when am I going to get my money? That's it. And so you let it grow dust and grow hair. And unfortunately, that's when the legal ombudsman gets involved. And you don't want that. So if you're trying to juggle things which are busy turnaround stuff, like conveyancing, like being out at court, it's really difficult to do that kind of work as well.
Is that why? Because I see a lot that you mentioned about the sort of the trusts work and how in a smaller firm that would be mixed in,
Yeah.
but in a larger firm they separate it out. Is that because of the nature of the work, or is that because, like you say, like the rhythm of the work? Does it not go together well, or is it just because it's more routine and so it's easier to hive it off to someone?
I think the reason it gets hived off is a risk management thing,
Okay.
because it has a lot of technicality to it. And whenever you're dealing with all a firm's trusts, you can put systems in place, you can ensure that you have a central trust diary, you are perhaps even at a point where it would make sense to have some software. If everybody's doing half a dozen, then there's no proper coordination of how you're doing it.
Right.
And that's where the risks come in, because trusts are very technical, and if you're and there's a lot of admin to them, but there's a lot of technical side to it and a lot of tax. So the
Mm.
risk is that you haven't got your mindset right on that. Probate, it's more general, and it's more
Mm.
generally things, it's letters and so forth, but you're probably having to give technical advice. There's a lot of regulation now with trusts. So, for example, we've got to comply with international rules for any trust that's got a foreign beneficiary. So family member goes to live in America, you've now got to think about FATCA, which is a foreign accounts tax system. You've also got to register trusts now. That's a big issue for most firms. In fact, you could probably get a job tomorrow if you're willing to learn that, because everyone's desperate to get through piles of trust registrations. So there's a lot of regulatory side to it, which
Mm.
is helpful and cost effective if you pull it all together.
No,
And in,
fair
and,
enough.
and in some firms, even a small firm, that would still be beneficial to have a couple of people who could do it,
Mm.
because it would cover for holidays and illness and so on. If there's more than one, it might not be the whole of their workload, but together they have got a system and they know how it works and they know what they've got to do in addition to the other things they're doing, you know.
Sure. Yeah, yeah. No, that all makes sense. That all makes sense. Well, that's great. Thank you for enlightening us. I think that was a great session. Such it's so good to just round it all up in one sort of bag, if you know what I mean. And I
Yeah,
think it's been
yeah,
useful. Some people have had to leave and said thank you, and other people have said thank you. So thank you
good.
so much for coming online today and sharing your knowledge and helping hopefully a few people make some decisions on their careers. So
You're very welcome. I've enjoyed it very much, and as I say, do follow me on LinkedIn. You'll keep up to date that way.
absolutely. No, that's great. Thanks for everyone for coming along and thanks for your time today, Jill.
Thanks, Clara. Bye.
Bye bye.